Thank you so much, Adam. Appreciate being here. Appreciate all of you taking the time to join our webinar today. I think we have a lot of very important information to put out there to folks. As Adam mentioned, my name is Anthony Tomaselli. I am the advocate for business at the Workers' Compensation Board. So what is that? Primarily, I'm the liaison between the Workers' Compensation Board and the business community. I really kind of look at it as having two primary objectives. One is to educate employers about workers' compensation, disability insurance, paid family leave, and the coverage requirements that you need to have to operate within New York State. And also put myself out there, make you all you folks aware that I'm here to act as your advocate, to take your questions, to help you with your issues, and get feedback and learn from you as much as I'm trying to help you learn from me. So, the best we can do is kind of jump on in and start putting this information out there. Again, thank you all for your time being here. So what is workers' compensation insurance? That's the big one. We are the Workers' Compensation Board, so that's the one that comes to mind first when you think about us. That's insurance to cover on-the-job accidents, injuries, and illnesses. What would happen is if somebody did have an accident or injury in the workplace, workers' compensation insurance would provide medical treatment and wage replacement for the injured or ill worker. We have this workers' compensation insurance to protect both employers and employees. And I really need to stress the employers part of that. A lot of people don't realize this isn't just about taking care of sick employees. This is about taking care of injured and sick employees quickly and efficiently so employers can get on with their business and continue to do business and protect you from, having to go to court and litigation that might come out of any of these accidents or injuries. The system exists as much for the employers as it does for the employees. Disability benefits insurance, that's the other type of coverage that we really handle here at the board. This is if there's an off-the-job accident, injury, or illness. In this case, we're really just talking about a limited wage replacement. We're not talking about the medical treatment, just a limited wage replacement if something happened to you outside of work that's preventing you from working. This is to help you take care of yourself and your family while you recover from whatever injury or illness you're struggling with. Employees can currently receive a wage replacement of up to $170 a week for up to 26 weeks. So who needs coverage and who doesn't need coverage? Well, if you're a business and you have employees, you're going to probably need coverage. What is an employee? That's really important. Who are my employees? Well, anybody that provides services for a for-profit business can be considered an employee. This doesn't necessarily even mean that you have to be paying them. They could be working for you for free. But if they're working for your for-profit business for the purposes of workers' compensation insurance, they are your employee. When you're talking about nonprofits, we do kind of specifically look at compensated individuals. So if you're a compensated individual providing services for a nonprofit, you could be seen as an employee of that nonprofit. There are some limited exceptions to that, such as clergy or teachers. But in most cases, if you're getting compensated and you're working for a nonprofit, you're an employee. So who needs to carry this workers' compensation insurance? Well, who is not? I'm sorry, let me read the slide. Who is not required to carry workers' compensation insurance? So if you're a sole proprietor, you have no employees. If you're partners in a partnership, you have no employees. Or if you're a one or two person owned corporation with no employees, yes, I know I'm reading the slide, but I'm just trying to get it out there. But really the theme on here, we got the last one here, LLCs, only people compensated are the members. The theme here is if you are the only person at risk, if it's your business and you're the only person that has anything to lose by an accident or injury on the job, you're probably not required to have coverage because it's on you. If something happens to you, you'll have to take care of yourself. When you start bringing employees in, you are responsible not just for them, but also their families and their livelihoods. So that's when you really kind of start having to look at getting that coverage. If you're the only one who has anything to lose, you can sort of get out of it. Not that it's recommended. We always kind of put it out there that just because you're not required to get workers' compensation insurance coverage doesn't mean that it might not be a good idea to go out and get it for yourself anyway. Because we all know accidents happen. You don't want to be on the hook for $1 million in medical expenses just because you don't need to. So everybody wants to know how do people figure out how much this costs? Where do these premiums come from? Well, there's a couple different factors that go into the premiums. We have the classification codes for every different type of occupation. Those are created by the Compensation Insurance Rating Board. Really, what we're looking at is how hazardous a job is. You know, if you're doing asbestos abatement, your classification code is going to be a lot more hazardous than if you are, just answering phones in a call center. The rates are determined generally by $100 per payroll. Size of payroll is going to affect it, how many employees you have. Your safety history, do you have a lot of accidents or injuries on the job? If you've had a lot of claims, your premium is probably going to go up, just like with your car insurance or your homeowner's insurance. You will also get periodic audits, how responsive you are to those audits and how well you handle your documentation could factor in. And then, of course, all your providers they're going to factor in their administrative expenses to actually providing the policy for you. So some specific coverage issues that come up that we hear about all the time, when we look at sole proprietors, who's responsible, who do I need to cover? We get a lot of questions about independent contractors and subcontractors, in those cases, who's responsible for the coverage. We also get a lot of questions about family members and domestic employees, and I'll try to hopefully address some of those as we go through the next couple of slides. So let's throw a scenario out there. Let's see if how well you're thinking about your insurance responsibilities here. So we got Jen's tutoring service. Jen wants to start her own SAT tutoring service. She's going to go out there and hire independent contractors for all her tutoring services. Parents are going to reach out to Jen, and they're going to ask her to match their child with a tutor. The parents are going to pay her, and then she's going to, in turn, pay the tutors. Is Jen going to be required to provide workers' compensation insurance for these independent contractors she's using to provide the tutoring services? I'm going to give you all a few minutes to try to answer this question. Let's see what you think right now going into this, knowing very little about workers' compensation insurance.
Thanks, Anthony. You'll see a poll on your screen. If you want to just put your answer in the poll there, it's simple yes or no. We do have some answers coming in, but as Anthony said, we'll give you a couple seconds to think about it and put in your answer. Looks like right now we have a pretty good, I would say it's probably about 70% of people are thinking that yes, Jen does need workers' compensation insurance. And Anthony, what do we think?
I think she needs it. She needs it. They're working under her direction and control. She's telling them where to go and what to do. So they're technically her employees.
All right. Very good.
So just kind of elaborating on that a little bit, the factors that are considered when determining whether an individual is an independent contractor or not for workers' compensation purposes. What we really want to look at is the control, the time, and the manner in which the work is done. We're all going to look at, the FEIN number from the IRS, who's filing the business tax returns, who's reporting the employees as payroll. But really, the direction and control, time and manner, that's the key when it comes to determining whether or not an independent contractor is your responsibility when it comes to workers' compensation. Direction and control. Did you tell them to be in the place that they're at, doing the thing that they're doing when they got hurt or sick? That's the responsibility, the accountability there. That's what we're looking at. Construction workers specifically, construction job sites can be a little bit of a paperwork mess, right? We've got general contractors, we got developers, we got subcontractors. Who's responsible for these people? Who has to cover all those employees that are on the job? The Construction Industry Fair Play Act says that workers on a job site are presumed to be employees of a company on the job site unless they can prove they own their own business. If you want to learn more about this, you can look at the Construction Industry Fair Play Act. That's where even if somebody's telling you they're an independent contractor, generally on a job site, unless they can produce proof that they own their own business, somebody else on that job site needs to be responsible for their workers' compensation coverage. So under the law, general contractors are liable for the workers' compensation claims of all uninsured subcontractors. So this means if you're a general contractor, you should make sure that you have enough coverage. You have the coverage for all the workers that are going to be on your job site. If you're using subcontractors, in order to make sure that you're sure that they have a policy and they're not just telling you that they have a policy, you're going to ask them to add you as a certificate holder on their workers' compensation policy. This way, if you're a certificate holder on their policy, you'll be notified if there's a lapse in coverage. Because maybe when you hired that subcontractor and you brought them on the job site, they had coverage, but if for whatever reason they didn't pay their bill or something happened, that coverage got canceled, you're going to want to know about it because you're going to want to know exactly what you're liable for on the job site. Penalties for noncompliance, they're pretty stiff. Okay, it can be up to $2,000 for every 10 days out of compliance or $72,000 a year. If you have up to 5 employees and you're not compliant, that's a misdemeanor subject to a maximum of $5,000 penalty. You got more than 5 employees, this is a Class E felony, subject to a maximum of $50,000 penalty and a maximum of 1 1/3 to 4 years in prison. So this is serious business. We take workers' compensation very serious here in New York. You don't want to mess around with this. Misclassification of your class codes, if you say that your workers are doing some other less dangerous activity than what they're actually doing, that's the same as being uninsured, and you can face the same penalties. Debarment, this is a pretty stiff consequence. Under Section 141B of the Workers' Compensation Law, you could be barred from bidding or being awarded any public work contracts or subcontracts with the state government or any local governments here in New York if you have a workers' compensation violation. The ban can be up to 5 years for each felony conviction. This is not something that you want to happen to you because it's not just about doing big government contracts like working on roads and bridges and things like that, but it also can come down to, just trying to get a permit to do a job. And also, I just need to put it out there that a lot of people will look at the debarment list, even if it's not a government contract and they're not required to follow it, they kind of use the debarment list as an informal vendor responsibility check. So some people may not want to work with you because you're on the debarment list, even though the law would allow them, because they're going to look at your presence on that list as just evidence that you're a bad actor. So don't get into trouble with your workers' compensation insurance. There is an appeal process. Okay, if you get a penalty letter, don't stick your head in the sand. Contact the board and appeal the penalty. Respond to any notices you receive from the Workers' Compensation Board. Really, that's probably one of the most important pieces of advice I could put out there in this webinar is if you get mail from us, respond to it. If you get a notice where we're asking you questions, that means that we have reason to believe that there might be a coverage issue that we're asking about. Respond to it. If you don't respond to it, we're probably going to think, down the negative path, and you're probably going to end up with a penalty. But if you get that penalty, respond to it. We can work with you. We can reduce penalties. We can even appeal penalties. Mistakes happen, and we want to work with you to fix that. So please, if you get mail from the Workers' Compensation Board, respond to it. Some suggestions to control premiums. Class codes, I mentioned that briefly before. Make sure that all your employees are classified correctly. That the right classification code. I used an example earlier of, saying that somebody's working a safer occupation that they're really doing. But you might make a mistake and list somebody as doing something more dangerous than the work that they're actually doing. In that case, it's going to cost you more money. Make sure you follow up on your claims, you stay informed, you're responsive to your carriers, and most importantly, operate safely. If you have no injuries or accidents on the job and you have a great safety record, just like with your car insurance or your homeowner's insurance or any other type of insurance, your costs are going to go down because they're going to see you as a low risk. Labor Management Safety Committee, this is a recommendation that we put out there. I was actually just speaking to another group about these this morning. You could do this formally or informally, but really, any type of regular meeting between labor and management to actually go through the workplace and the tasks that you're doing and take a look at the activities and see what are my employees facing that's dangerous? What hazards and risks are out there that they're coming up against? Give them an opportunity to speak up about it. Sometimes your employees might be looking at the same hazard every single day and not feeling comfortable saying something about it. If you've got a labor management safety committee working together, reviewing these items, give them a forum to speak up about these things so you can address them. So, just more on this, the same kind of thing, go through the site together, come up with procedures and policies together. Make sure that everybody that works for your company understands that safety is a priority for everyone. You should care about the safety of your workers. They're helping you make a living. They're helping you feed your family. You're helping them feed your families. You all should be looking out for each other. One program we like to mention that the Department of Labor is a workplace safety prevention incentive program. It's called Code Rule 60. If you voluntarily set up a safety plan, a drug and alcohol plan, or a return to work program, these programs can save you up to 10% on your comp insurance for the first year, up to 6% in the second and third years. There's a website on there, labor.my.gov/WSLPIP. If this is something that you're interested in or you want to look into, reach out to these folks. And if you're not catching that website now, you can reach out to us and I can help connect you with the people behind this program. But it's something to do, particularly if you got a larger payroll and your premium is pretty large. Knocking 10% off the first year or 6% off the second and third years can be a big deal. It can save you quite a nice chunk of money. So Department of Labor also has an on-site consultation program. This is separate from the other program that I was mentioning, but you can actually call the Department of Labor without any risk or cost, and they'll come to your workplace and walk through and consult with you on the safety of your workplace. And they're not going to use that as an opportunity to try to slam you and get you in trouble. They really are about just trying to help people have safer workplaces, reduce accidents, reduce injuries. And as I mentioned before, if you can reduce accidents, reduce injuries, operate safely, it's going to reduce costs. And we all love to reduce costs. So just kind of review employer responsibilities, things that you need to do regarding workers' compensation insurance. Get the required insurance. Display your required insurance poster. When you get a policy with a carrier, they're going to send you, like a policy packet with all kinds of materials. One of the things in there is going to be a poster for you to put up in your workplace to let all your employees know that they're covered, that their employer has coverage, and who the carrier is that has the coverage and what to do if there's an accident or an injury. You do need to report claims timely. The law actually requires you to do so within 10 days, but this is also in your best interest. Getting an accident or an injury taken care of quickly usually means that the worker is going to get back to work quickly, which is in everybody's best interest. You cannot discriminate against employees for filing a claim. You can terminate employees who have workers' compensation claims, but only for a valid business reason, such as misconduct, insubordination, or economic reasons. But you cannot, just because they filed a claim, hold that against them. All your employees are eligible, regardless of their citizenship or immigration status. Keep that in mind. You can't just ignore people's coverage requirements because they're undocumented. They're human beings. You got to be responsible for their safety and health, welfare as well. So let's talk a little bit about paid family leave. That's new it's not so new. We're a couple of years into it now, but for some people who've been doing business for decades, it is kind of new. New York State paid family leave. This is something that came into law a few years ago, and really we're providing job-protected paid time off for the big three: is bonding with a new child, caring for sick family members, and then also assisting your loved ones and family members during a military deployment. When we're talking about bonding with a child, time off for both parents within the first 12 months, and this covers births, adoptions, and foster parenting situations. So anytime you bring a new child into your family, PFL is available for you. When we're talking about family members with health conditions, qualifying family members you got quite a group here. We've got not just your spouse and your children, but your siblings, grandparents, parents, step-parents, domestic partners. This was just updated in 2023. So they got some new options for the siblings. So definitely want to make sure your insurance carrier has any details on if your policy changed. Your family members can live outside of New York. That's kind of important to know as well. Even though you're in New York and it's New York State insurance coverage, you can use this benefit to take care of a family member outside of New York. When we're talking about serious health conditions, this is the definition we're using. We're looking at illness, injury, impairment, sorry, or physical or mental health condition requiring either inpatient care or continuing treatment or supervision by a healthcare provider. And this can include COVID-19 as a serious health condition. Military deployments, if anybody's part of a military family, short notice deployments happen. Military events, activities, rest and recuperation when coming back from military service. This is, not an easy thing for a family to go through. And this PFL is here to help families manage it, manage this transition, manage the stress and the changes that a family has to go through, when a family member is deployed and returning from deployment. So most private employers are required to have paid family leave insurance in New York State if you got one or more employees. It's the law now. You have to do it. Sole proprietors, other self-employed individuals can voluntarily opt in for coverage. Remember, I was kind of mentioning before, your responsibility for yourself, for your risk, but also your benefits. But if you want this coverage as a sole proprietor, you have to voluntarily opt in. And you got to do so within the first 26 weeks of starting a business. If you don't do it within the first 26 weeks of starting a business, you have to wait 2 years before you can then try to opt in again. Eligible employees can take up to 12 weeks of paid family leave at 67% of their average weekly wage, capped at 67% of the New York average weekly wage. Okay, this will be based on the last 8 weeks of pay prior to taking the paid family leave. And as of 2023, we're looking at an average weekly wage of $1,688.19. And employees can take this time off all at once or intermittently, but you have to do it in full day increments. You can't do it an hour here, an hour here. It has to be a day here or a day there or days in general. So who's paying for this coverage? Well, when we're talking about paid family leave, this is going to come out of the employee payroll contribution or the employee's money, really. So DFS sets employee contribution rates to match the cost of coverage. And you can find more information about this and a calculator on paidfamilyleave.ny.gov/cost. Who's eligible? Cover employees are eligible to take paid family leave once they've met the minimum requirements, which for full-time employees are a regular schedule of 20 or more hours a week after 26 consecutive weeks of employment. Part-time employees, that's if they work a regular schedule of less than 20 hours a week, but they are eligible after they've worked for their employer for 175 days, which does not need to be consecutive. So citizenship or immigration status is not a factor in employment eligibility. So what I want to mention here is notice that there is a difference. When we're talking about workers' compensation coverage and then the disability insurance and paid family leave coverage, it doesn't all match up. So that can create an area of confusion for some folks. And this is why it's really, really important. And I'm going to stress probably, again, at least 2 or 3 times before this program is over, webinar is over, is that you should be talking to your carrier. You should be talking to your insurance agent and your insurance carrier. Bring them in close. If you're an employee, you want to bring them in close, like as if they were your accountant or your lawyer. And just stay in touch with them, talk to them, let them know about changes, check in with them, make sure. Don't just trust that all your stuff is going to get handled the way it needs to be handled and your PFL is going to kick in for your part-time employees at the right moment, at the right time. Check up on this stuff. Talk to your carrier. Make sure. Look at what you've got and look at what you need and communicate with the insurance professionals. So can an employee waive coverage? Paid family leave coverage is not optional for most employees, but some part-time or seasonal workers can. So if you regularly work fewer than 20 hours a week and you're not going to work 175 days a year, you can opt out of the PFL coverage. If you work 20 or more hours a week but won't be in employment with that employer for 26 weeks, you can also opt out of coverage. The PFL contributions are small though, so I don't know as an employer if it's something that you want to be recommending your employees do or not, but I would, you do want to let them know. You do have to let them know that the option is there and they can waive the coverage if they meet these requirements. Can a waiver be revoked? It's a good question. The schedule changes so that the person no longer qualifies for a waiver. The waiver will be automatically revoked within 8 weeks of the schedule change. And then the employee will begin making their contributions and any retroactive payments that are due. So key responsibilities in the paid family leave area: get the coverage that you need, pay the premium with the funds collected from the employee payroll deductions, get that all set up properly. Make sure that you provide information about paid family leave to employees. As I mentioned, just like with the workers' compensation, you should get a poster and some information from your carrier that you could put up in your workplace so your employees can see it. Make sure that that information is visible and share with the employees. Make sure you're communicating with your insurer as far as wage information, and let them know when an employee requests paid family leave. And as I mentioned in one of the previous slides, we do have a nice website here, paidfamilyleave.ny.gov. And there's a lot more information and details about paid family leave if you want to do a little bit of individual research and just check it out, learn some more. So I'm going to kind of segue into COVID-19 because it's still kind of a bit of a hot topic, especially right now. It seems to be going around again. If there is a COVID-19 diagnosis in your workplace and somebody tells you that they tested positive, you're going to report it to your insurance carrier. You can file a claim with the board. You could get quarantine leave. That was a big thing I know a little while ago, and I know not really happening now, but it could come up again. We could start having to deal with these quarantines again. If we did, just kind of put it out there that you can use paid family leave if you have a family member who is in a COVID-19 quarantine situation. And, the same PFL benefits are there and available. And you have 67% of the pay, and you can combine that with disability benefits. But really, we'll be talking about those situations if you start getting hit with those mandatory quarantines. I know right now we don't really see a lot of that going around, but this is kind of how we set things up, how the law was set up. When COVID was a bit of a thing, and you never know; it could happen again. So you should be prepared for it. You should be knowledgeable. So as far as if you have to implement quarantine leave. There's really nothing more for me to add on that. If this situation happens, talk to your carrier, let them know, you have a situation where somebody is in quarantine and wants to use their paid family leave benefit. And again, talk to your carrier, talk to your employees, keep an open mind, see what goes on. So mention that website again, paidfamilyleave.ny.gov. You also have a helpline with an attorney today on call to answer paid family leave questions at any time. That's 844-337-6303, 844-337-6303. Also going to take this opportunity to plug our new business information system. The Workers' Compensation Board is trying to leap forward into the 21st century and get the onboard system, we're calling it, which is going to provide access to real-time claim status and a number of online self-service tools and e-forms. If you want to stay informed with us, go to wcb.ny.gov/onboard to learn more about it. But we're hoping to kind of transform and revolutionize the workers' compensation experience with this. So you can follow us. We're on, I guess we're calling it X now, at NYS Workers Comp. The Facebook there at NYSWCB, Instagram, NYS Workers Comp Board, YouTube, wcb.ny.gov/notify. That's our notification. I think most of you who signed up for this webinar are probably getting notifications from us already. But if you're not, sign up and get them from us because you never know. We're at the whims and whimsy of the law. And when things change, you as employers, you want to stay up to date on things. You want to know when these changes are happening, when they're going to affect you. This is an important part of your business. You've got to have these types of coverage if you want to be an employer in New York State, which is you got to try to stay informed and be responsible for it. Hold the professionals that you work with accountable and communicate with them and trust them. Staying on our notification system is a good way to do that. This is my contact information, my office, the Advocate for Business office. You can reach us at 518-486-3331. We also have an email, advocatebusiness@wcb.my.gov. And we're really here to kind of help you with any kind of employer questions or employer issues. Don't really look at it as a way to just try to cut the line. If you got a penalty notification, follow the instructions that are on there to respond to it. But if there's some kind of weird circumstance or issue that we might not be aware of that you really want to talk through and get some advice or feedback on, that's what we're here for. And you can call us and you can reach out and ask us questions. Also, if you just have any thoughts or comments as far as your experiences as an employer who has to get these types of coverages, you can share that with me as well. I do report directly to the chair of the Workers' Compensation Board, Clarissa Rodriguez. And if there's a great proposal or if there's an opportunity or a way that we can move forward and try to help businesses, I would love to hear it. So, keep this information handy and please reach out. I believe there's a bunch of questions that were kind of popping up in the chat. If you want to just give us a few minutes to take a look at them, we'll come back and try to answer them as best we can.
All right. Thank you, Anthony. As Anthony mentioned, we do have questions that have already come in. We're going to take a look at those. But again, if you have questions, feel free to put them in the chat box. And I do want to point out, we will be updating this recorded version, and it will be on our YouTube page. Anthony mentioned signing up for email notifications. We encourage you to do so if you're not already, because when that recording is ready, we will notify you via email. Again, it will also be on our YouTube page, so make sure you check that out. We do have a previously recorded version of this presentation already on our YouTube page, so if you need a refresher before the new version is available, again, just go to our YouTube page, check that out. You'll see I have the helpline and the email up for you now if you want to jot that down. And as Anthony mentioned, we are going to go back and take a look at some of the questions that have already come in, and we will be back with you shortly. Thank you. All right, so our first question here, Anthony, how does having employees working from home impact their premiums?
Well, that's actually a question that you'd want to take to your carrier because they're the ones who determine your premium. But I would think that as part of your audit, and part of your general communications with your carrier about what your employees are doing, that should be something that they take into consideration when they're setting up with your premiums.
All right, we have a question here, Anthony, about coverage for apple pickers hired and wages paid by a for-profit labor services New York State company with a New York State SUNY agricultural teaching research program. So who would provide the coverage in that instance, or where should this person be directed to?
So I'm actually going to say reach out to me directly on this because I want to investigate this one a little bit further. Generally, when we're talking about farmers and farm labor contractors, which are usually the contractors that provide the laborers to farmers, workers' compensation law says that the farmer is responsible for the workers' compensation insurance of the farm workers. With the farm labor contractor would be required to, make sure that they have coverage for their own employees that are doing things like transportation, bringing the farmers back and the workers back and forth to the farm, or other types of employment services. But when it comes to the State University of New York, things might be a little bit different because this is a teaching research program. So I don't want to go on the record with that answer for this specific question. What I would like you to do is send an email to the advocatebusiness@wcb.my.gov with that question, and I'll see if I can get you a better answer.
In terms of PFL coverage, if someone wants to take care of a sick family member who lives outside of the United States, are they eligible?
Yes, that was a good one.
So how do you propose employers handle notices for workers' comp and PFL with remote employees who don't have access to a bulletin board? I know you had mentioned there's flyers that need to be hung up in the building, but what about for those remote employees who don't have access to that?
My recommendation here would be, distribute the material electronically, to all your employees. If you have the ability to set up some kind of a hub resource or a web page that you can put these types of materials on for your remote employees to access, that would be a great way to address this. But I think the most important thing that for you to do is just keep communicating regularly with your employees. Let them know about their rights as employees working for you. make sure that they're aware that you do have the appropriate coverage, that they are protected if there is an accident or an injury, that even if they're working remotely, if it's job related, that you want to help them address it as quickly as possible in a way that gets them the care that they need and gets them back to work as quickly as possible.
All right, in terms of COVID-19 claims, would would workers who file compensation for COVID-19 claims, would that increase the premium for workers' compensation?
I would say it would be like any other type of claim instance that you're going to deal with. A few times, accidents happen. We all know accidents happen. People get sick. But if it starts to become like an epidemic, if you're filing claim after claim with employees continually getting sick to the point where it really looks like you are operating an unsafe workplace, your premiums are going to go up.
So does the board notify employers when a pre-conference hearing is scheduled for a claim?
To the best of my knowledge, yes. You should be responsive to any notifications that come to you from both your carrier or from the Workers' Compensation Board. And if there's a pre-conference hearing for a claim, you should be notified and you should go. You should be there to make sure that what's being said is accurate. That's a piece of advice when it comes to claims for all employers. Just follow your claims. If you have an employee who files a claim, follow it. Stay on top of it. Sometimes these things can go on for a while, but you definitely want to stay on top of it. And I'll use this as an opportunity to just remind all the employers on the call that you need to keep good records as a business owner. Not just your accounting records and your inventory records, but your records of who's working for you, what kind of tasks they're doing. If somebody has an accident or an injury on the job, your documentation, your record keeping is going to be critical to making sure that claim is handled appropriately. We get lots of questions about fraud, workers' compensation fraud. How do we know that this accident or injury really happened on the job? Well, a lot of that's going to come down to your documentation as an employer and how fast and how promptly you address the claims. And this is where it is in your best interest as an employer to take care of these things right away. Have the employee file that claim within the 10-day window. When it's very obvious to the doctor, oh, this is an injury that happened, and this is how it could have happened. And then you keep those records and you document that whole experience going forward. And that's going to protect you and cover you, from any type of fraudulent claim situation that might come up.
If there's an employee that moves out of state, but they continue to work for a New York State employer, what workers' compensation insurance is needed for that employee? Would it be New York or would it be the state that they move to?
So your workers' compensation insurance, you need to get it in the state where the work is being performed. So that, for New York employers, if you have employees that are working in other states, like South Carolina, for example, you're going to need to get a policy that covers the employee in South Carolina. Okay, and the same thing if you're an out-of-state employer and you want to come and hire people that are going to do work for you here in New York, you're going to need to have New York workers' compensation coverage.
Where can we get the flyer or the poster to hang on at our office?
So your carrier should have sent that to you. If you don't have one or you need another one, the place to go is back to your carrier and let them know that you need the flyer or the poster.
So do employers have to report all employees with COVID-19, even if they're only out for, say, five paid days?
So while these benefits are available, and COVID-19 is included under the PFL umbrella, it's not necessarily a requirement. And, you got to look at how you're running your shop as an employer. And, if one of your people gets sick and they want to keep working from home, say remotely or something like that, and they don't want to file a claim or they don't want to take any time off, they can do that. Or if they just want to take a few days off and you're already giving them the sick leave and they don't really need to file a claim, you can do that as well. It's really kind of only, I would look at that situation where the employee needs to access that benefit for one reason or another. Whereas the COVID diagnosis and the impact of the COVID on that individual is pushing them beyond the means of what you as an employer or they and the benefits that you provide to them can handle. this is available to them, but it's not. I wouldn't say it's required. And I think that's kind of one of the things that we kind of gets a little tricky when we talk about this stuff, particularly when we're talking about the quarantine coverages. We need to put this information out there because it could happen again. You as employees, you remember you did struggle with this. We all had to deal with this, in the early days of the pandemic where we had these quarantines that were kind of being pushed upon us. We didn't really have a choice. We didn't really get into our routines and our practices that allowed us to work safely, even with, the presence of COVID-19. So we're putting that information out there to you, to keep you informed and let you know what's available to you. But long story short, you don't have to report an employee with a COVID-19 unless they really want to look to access this benefit to assist them as they manage this particular COVID-19 benefit. I hope that helps and I didn't just confuse everybody even more.
Hey, Anthony, can you quickly review again the process for getting discounts on your premiums?
So I think you're referring to the Code Rule 60 program that I mentioned from the Department of Labor. So you're going to reach out to them. And, what I've learned about that program is you're going to set up the three types of plans, one, two, or all three of them, the safety plan, the return to work plan, and the alcohol and substance abuse plan. And there's guidance available for helping you do that. Then they have a list of approved contracts who will come in and help you and give you guidance and approve that plan. And once you've gotten that plan approved by the approved contractor, then you'd be able to submit a certificate to your insurance carrier to get you that discount. I'm not aware. I see somebody else put a question about a COVID-19 policy with respect to their premiums. I don't know of any official programs, either at the Department of Labor or anywhere else, that specifically address, COVID-19 plans and how they would affect their premiums. But, this could be an excuse to start a conversation with your carrier. You never know. You never know what kind of credits, what kind of, discounts are available from your carrier if you don't ask. So again, talk to your carriers, communicate with them, and see what they can do for you.
All right, we do have a question here. In terms of independent contractors working on 1099s, we had mentioned that the employer will most likely need workers' comp policy for those independent contractors. But what about for disability insurance and PFL? This person who asked this question, their disability insurance is through NYSIF, and they believe that it does not cover a 1099 employee for disability. And for PFL coverage as well.
My recommendation is, I think you're probably right, but I would check with the insurance fund, because every situation is different, depending on the type of work that's being done. I would check with the carrier and discuss the issue with them specifically and make sure that there's no gaps in coverage that you need to be aware of.
So if an employer hosts an event and it turns into the term we used to call super spreader events for COVID-19, and it was required to attend the event, would this be filed under the PFL or under workers' comp?
It depends on the benefit that you're looking for. If you're trying to say that, you got sick on the job and you're looking for the medical treatment and the paid time off, that would be a workers' compensation claim. If, your super spreader event is, just cause you to have to quarantine and, or, a family member went to the super spreader event and you had to quarantine to take care of them. And that's really what the issue is. And you're really just looking for the additional support while you take care of yourself and take care of the family member. That would be a PFL claim.
I do want to take this time to kind of plug ourselves here. We have a couple questions here on the PFL subject. We are going to be having some PFL webinars in the coming months for both employees and employers. So I strongly encourage you to attend those. And we, again, just like today's session, we'll give you a presentation, give you the opportunity to ask us questions. Those can be found on paidfamilyleave.ny.gov. I know the employee webinars are coming up in the next couple of weeks. We will be announcing some employer webinars as well in the coming weeks. So please make sure you're aware of those. And I encourage you to join us for those as well, so you can ask any questions pertaining to PFL. What about asking for a liability insurance from a 1099 or a W-9, Anthony?
See, that's not really something that you need to be concerned with as an employer. Liability insurance, we're talking about a different kind of a risk. We're not talking about the risk of a workplace accident or injury. We're just kind of talking about, an accident, an accident that happens that's not really necessarily related to somebody performing work to help your for-profit business. So it's not really for you to ask or even be concerned with whether or not your 1099s have liability insurance.
All right, so if an employer rents a space for a host as a host of an event or a party, should they ask for insurance certificates? And for an example, if they rent a bouncy castle for birthday parties, should they also ask for certificates too?
So we need a little bit of more information to figure out exactly what kind of coverage we need in this situation. If you're renting space from someone, but there's no workers there working, their liability insurance is going to cover any accidents or injury that happens in that space. If they have workers who are actually working, doing the work, they're going to need to have workers' compensation to protect those individuals from an accident or injury that happens to them while they're working. I think that's, regardless of whether we're talking about a bouncy castle or whatever, are there people performing work under direction and control of the employer? Then they need to have coverage. Somebody standing there blowing up the bouncy house, deflating the bouncy house, pulling all the kids out, whatever, they're probably gonna need to have coverage somewhere. But if you're, a homeowner or a mom or a dad or somebody renting a bouncy house and you just rent it and take it home, there's no worker there to have workers' compensation coverage. That's going to be, covered under the liability policy of the rental place, or also, maybe, look at your homeowner's policy. Sometimes these claim issues, if there's an accident or injury, can get pretty sticky, and that's why we have these hearings, and the judge kind of helps sort it out. Who is responsible for the accident or injury?
They did clarify, Anthony, they are a nonprofit organization. They rent space to the community.
Okay, but are you staffing it with employees? Is kind of really the question, or not. That's where it would determine whether or not you need to have coverage or not.
All right, we have a question here. The questioner, Anthony, they say they didn't voluntarily opt into their disability coverage. I'm going to assume they're talking about PFL coverage. They are eligible as of February 2024. But they did just have a baby in August, and they want to know, are they allowed to take time to bond with that baby after they're eligible following February of 2024?
Now, as we mentioned in the slide, you have up to 12 months to use your PFL benefits. So if your statements on the timeline are accurate, and you become eligible in February, but you had the baby in August, it looks like you still have a window there between February and August of 2024 where you could access the benefit.
All right. Unfortunately, we do have a hard stop at 1 o'clock. We do have a couple more questions. We aren't going to be able to get to all of them. However, again, the helpline and the email address are on your screen right there. So please feel free to jot that down. Shoot Anthony an email. Give him a call. We are going to take one more question, though, before we sign off. So why wouldn't someone want to confirm that a 1099 has a liability policy?
I guess, to dig into this a little further, what risk or what hazard are we concerned about here? And I guess that would kind of come down to the question of when you're talking to your 1099, the different types of insurance are to cover different types of risks. And how do you think the risks that would be covered by the 1099's liability policy affect you? As an employer, as your workplace, that's kind of, I think, the root of this question of whether or not you need to know if they have a liability policy or not. But this isn't something that I generally talk about with employers or get questioned about a lot. So, like in many of these other situations, I would, if you are identifying a specific situation where you think you have some risk exposure, and that's kind of what you're looking at here with where you think maybe your 1099's liability policy will cover it, to be sure, I would talk to your insurance professional. I would talk to your insurance carrier and bring up whatever the situation or the risk that you're concerned about is. and ask them, who covers this situation? Who covers this set of circumstances that if this type of incident happens, which policy is going to be the one that steps in and takes care of it?
All right. Thank you, Anthony. We are going to wrap up. Again, if you have a question that we don't get you today, or if you think of something later, feel free to shoot the Advocate for Business an email at theadvocatebusiness@wcb.ny.gov. Again, I want to thank all of you for joining us today. We had some great participation today. We always love to see that. Thank you to Anthony for taking the time to give the presentation and answer questions. Just a reminder, this series will continue to be offered in the coming months. You will be getting an email shortly with the next set of dates. Make sure you leave some time on your calendar if you want to join us again. Again, I do want to point out we will be providing a copy, or I should say a recorded version of this presentation on both our web page and our YouTube page. Just make sure you're signed up for email notifications so you know when those are available. To do so, you can visit the Workers' Compensation Board website at wcb.ny.gov. Scroll down to the bottom of the homepage and select Get WCB Notifications. We also distribute information via social media, so make sure you are following us on Facebook, X, formerly known as Twitter, Instagram, and YouTube as well. Again, thank you all for joining us and enjoy the rest of your day.